comport with the victim impact portion of the statute and is specifically addressed to the defendant rather than impact on the loss of disturbance to her family or community.
That sentence. Then the last sentence that's objected to is the first sentence on the last paragraph on page 2. And I'll read that into the record. In their closing statement, the defense said, quote, the events that unfolded that day will haunt the defendant for the rest of his life, end of quote. Statement.
Your Honor, I defer to the court.
Judge, again, my position is the same. I don't think it complies with the victim impact section.
Okay. I'll sustain the objection as to that sentence.
Judge, while we're on the subject, I would ask the court for each individual person that comes forward to read these letters that prior to that, before they start reading the letters, the court give the victim impact instruction that's in the definitely jury instructions. There's a comment above the victim impact paragraph that says, if requested, please instruct the jury.
There was another instruction I would give, but I'll look at that one to see if appropriate. That instruction reads as follows. We would change it for future tense instead of past tense. It reads, you have heard evidence about the impact of this murder on the family, friends, and community of Amanda Colley and Lindy Dobbins. This evidence was presented to show the victim's uniqueness as individuals and the resultant loss by Amanda Colley and Lindy Dobbins' death. However, you may not consider this evidence as an aggravating factor. I was going to read the instruction that was given in Alston versus State and upheld by the Florida Supreme Court. For the record, that was located at 723 Southern 2nd, 8148, Florida Supreme Court case of 1998, which reads as follows. You are about to hear victim impact evidence. You shall not consider the victim impact evidence as an aggravating circumstance, but the victim impact evidence may be considered by you in making your decision. So tell me which one you prefer.
I'd like the one that's in the jury instructions, Judge. I'm still, despite the language that's in Alston, I'm concerned the jury may not fully understand or may misinterpret that language to think that victim impact evidence is an aggravating factor to consider in this case. Of course, with the caveat that you just mentioned, it'd be in future tense. You're about to hear.
Correct. All right, here's how that would read in future tense. You are about to hear evidence about the impact of this murder on the family, friends, and community of Amanda Colley and Lindy Dobbins. This evidence is presented to show the victim's uniqueness as individuals and the resultant loss by Amanda Colley and Lindy Dobbins' death. However, you may not consider this evidence as an aggravating factor. What do you want to read?
Yes, sir.
Okay. You're asking for it to be read before each victim.
Yes, sir.
I mean, I think that's, I don't have an objection. I just think that's a bit
redundant.
Redundant, yeah.
Yes, sir. We're always concerned about this type of evidence coming up for constitutional reasons.
This is a bigger font too.
The statement implies I
don't have time to do
this. Will be reading the victim impact statements to keep their statements confined to those written statements and that cannot deviate. I very much appreciate that. It's going to eliminate any problems. Anything else you need to take up this morning?
I don't think so.
All right. I'll have some housekeeping matters with the jury first before I instruct them. Housekeeping matters, we make sure they haven't seen, read, or heard any media accounts of this case since we last saw the jury, and then I'll do that secondary polling as we talked about on Friday, and that should take just a couple of moments, both of those two things. Then I will get into the preliminary instructions, standard instruction 7.10. And when I'm done with that, you will present your opening statements and then state opponent's evidence, defense opponent's evidence. So you have evidence ready to go this morning?
Yes, sir.
Okay. Well, how would you want to do it? Okay, let's bring it up. John? Go ahead, Mr. Colley. It'll take a few moments. Get up there, that'll be fine.
I need you to go run and do this one. I had to handwrite. Oh, shit.
To our TV guy back there. Good morning. Could I bring the jury in, please? Yes, sir. Welcome back, folks. Welcome to see you. Welcome back, everybody. Everybody remembered their seats, so it's greatly appreciated. Hope everybody's doing well. Good to see you all again. We are about to proceed with the next phase of this trial. Before we do that, I have a couple of housekeeping matters to take up with you. First off, I'm going to ask you, as I did every day before we started court last week and the week before, I just want to assure that none of you have seen, read, or heard any media accounts of this case since we last saw each other last Wednesday. Everybody's shaking their head no. Did anybody see, read, or listen to any media accounts? Okay, everybody's saying no. Okay, great, thank you. Let me cover one other thing with you before we get into what we're here for today and this week. When we were together last week, your verdicts on count 1 and 2 of this case, if you're in that verdict or verdicts, you found the defendant guilty of first-degree murder for each of those counts. But also on your verdict form checked off the firearm boxes. The firearm boxes were under the lesser included offense of second-degree murder for counts 1 and 2. The questions of whether or not the defendant actually possessed a firearm, discharged a firearm, and caused great bodily harm or death to the victims for those counts. That question wasn't asked for first-degree murder, so I just want to ask each of you individually. I know that I polled you, or the clerk polled you after the verdict last Wednesday, that the verdict that I read was your verdict, and each of you said yes, but I do want to ask each of you again this morning just to confirm that talk to you about scheduling a little bit. This process for this phase of the trial, reasonably confident will be done no later than Thursday. So I wanted to give you all that information. I'll keep you up to date on the schedule as we go along, but I don't anticipate it will be any longer than that. When you get to deliberating this part of this trial, the same rules about sequester are going to apply that they did during the first phase of the trial. So again, give you those instructions as we get closer. Again, no cell phones, no electronic devices, etc. when you deliberate. You have to be sequestered while you deliberate, so if your deliberations go overnight, we'll have you bring a bag and same parking arrangements and all of that. So I'll discuss that with you as we get closer. What I'm going to do now is read to you some preliminary instructions for this phase of the trial. You're not going to have a copy of these instructions as I read them to you now, but as with the first phase of the trial, when I get to the final instructions on the law that you have to follow in rendering your verdict in this phase of the trial, you will have a copy of those instructions with you when I read them to you and when you deliberate the verdict with regards to this phase of the trial. And I assure you they're not as long as they were for the first phase of the trial. I know those were quite long. So please pay careful attention. When I'm done with these instructions, the attorneys are going to give you their opening statements if they wish to do so, and then we'll get into the evidence and testimony. Members of the jury, you have found the defendant guilty of 2 counts of murder in the first degree. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of this trial, is presented in order for you to determine, as you will be instructed later, whether each aggravating factor is proven beyond a reasonable doubt, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, whether mitigating circumstances are proven by the greater weight of the evidence, whether the aggravating factors outweigh the mitigating circumstances, and whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after the arguments of counsel, you will be instructed on the law that will guide you in your deliberations. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you have unanimously found to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. Now that concludes my preliminary instructions for this portion of the trial. At this point, the attorneys will give you an opening statement if they desire to do so. And we will begin with the state's opening statement. State, you may proceed.
Judge, I think it might be appropriate to invoke the rule at this time and so instruct the witnesses.
Okay, if there are any witnesses in the courtroom, please step outside.
Judge, we have some in the hallway.
All right, you can advise your witnesses accordingly.
Your Honor, we have our victim impact witnesses. Would you like them to step outside as well? Or?
Are you voting?
No,
or not? Okay, very well. Okay. State, you may proceed with your opening statement.
Mark is going to instruct me next day.
Good morning, ladies and gentlemen. You have found the defendant guilty of 2 counts of first-degree murder. So we are now at that second phase of the trial that you've heard about throughout your time with us, the penalty phase. And this is the time where you will be asked to consider the death penalty as an appropriate sentence in this case. As far as the state is concerned, this is not something that we take lightly. We understand that this is a solemn and somber responsibility that you have before you in this case. But there are some first-degree murder cases based on the circumstances of the murder, the background of the defendant, and the law that are appropriate for you to consider the death penalty, and this is one of those cases. During the guilt phase of the trial, the focus was on proving the elements of the various charges, the murder charges, the attempted murder charges, burglary, and aggravated stalking. Well, now, during this phase, the focus is different. As you've already heard the judge sort of explain to you what you are to consider, we are now required to prove what is called an aggravating circumstance or a factor. And that is something that is set forth in Florida statute, a circumstance or a factor that elevates or heightens a first-degree murder under the law to be able to be considered for this punishment, the death penalty. You may also be presented with mitigating circumstances during this phase. And once you have heard all of the aggravating factors and the mitigating circumstances, there will be a process, and it will be explained to you at the end, that you will go through in weighing these aggravating factors and mitigating circumstances in order to come to your decision. Now, all of the evidence that the state brought forward to you in the guilt phase, all of the evidence that supports our aggravating factors we will later be arguing to you has already been presented in the guilt phase. You know, there was a lot of detail and additional testimony and evidence that was gone into that we did in the guilt phase, knowing that there was a possibility of a penalty phase and that we would be arguing that to you at this time. So we don't want to waste your time in presenting it again here this morning. I say that just to know that our portion of this phase will be relatively brief this morning. You will hear from a few family members of Amanda Colley and Lindy Dobbins. And that'll really be the extent of what we present here this morning. And that's not to minimize the evidence that we have in this case and that we'll be arguing to you at the end. It's just that our work proving those circumstances has already been done for you. It may be that other evidence may become relevant throughout this process, and if it is, we will present additional witnesses and testimony at the appropriate time. I want to talk to you now about the aggravating circumstances that the state is prepared to prove in this case, and you'll understand when we go through them why I say that a lot of that evidence has already been presented to you. There are 5 aggravating circumstances that apply in this case as to count 1, the killing of Amanda Colley. And there are 4 aggravating circumstances that apply to count 2, the killing and murder of Lindy Dobbins. The 4 circumstances that apply to Lindy Dobbins also apply to Amanda, and then there's an additional one for Amanda that I'll discuss with you. I'll start by talking about the 4 that apply to both of them. And keep in mind that even though legally each aggravator applies to both homicide, the evidence and the facts supporting that aggravator as to each victim may be different, and we'll point that out to you in our arguments at the end. The first aggravator in this case that applies to both homicides is that the defendant was previously convicted of another capital felony or a felony involving the use or threatened use of violence. Now that word prior is a little misleading with this aggravator because under Florida law that also means contemporaneous to or at the same time. And I'll explain that to you. The second one that applies to both murders is that the murders were committed while the defendant was in the commission of a burglary. The third is that each of the murders in this case was especially heinous, atrocious, and cruel. The fourth is that each of the murders in this case were committed in a cold, calculated, and premeditated manner without pretense of moral or legal justification. And so those are the 4 that apply to both homicides. And then as to count 1 in Amanda Colley, there's an additional aggravator known as the domestic violence injunction aggravator. And that aggravator stands for the fact that the murder was committed by someone who was subject to an injunction and that he killed the petitioner of that injunction, in this case, Amanda Colley. Now I want to go back and kind of explain some of the evidence that has already been presented to you as to each of these aggravators. With respect to the first one, the aggravator that I said deals with the fact that there is a prior or contemporaneous capital felony or a violent felony. The defendant has both in this case. The judge will instruct you and explain this aggravating circumstance further, but basically it means the fact that he was, as to the capital felony, the fact that he was convicted of 2 homicides. Lindy's homicide can be used to aggravate the homicide of Amanda Colley, and Amanda Colley's homicide can be used to aggravate or legally find that aggravator as to Lindy Dobbins' homicide. In addition to that, we also have the 2 attempted murders of Rachel Hendricks and Lamar Beverly. Those are also violent acts, use of violence or attempted use of violence, and both of those attempted murders are to be used in consideration in the aggravating factor against both Amanda Colley and Lindy Dobbins. The second aggravator, the fact that the homicides were committed while the defendant was in the commission of the burglary, you as the jury have already unanimously established that factor when you found him guilty of a burglary at the time of the homicides. The third aggravator, the fact that the homicides were especially heinous, atrocious, and cruel. You will hear that this means that the crimes were extremely wicked or shockingly evil. You have the crime scene evidence in the testimony and the photographs from crime scene technician Vollmer. You have the testimony from Dr. Bulick, who took a lot of time in explaining the various injuries to both victims and how those occurred. And again, in this case, you have the 911 calls that you've already heard. And those 911 calls provide a glimpse into that house, and that evidence supports that Lindy Dobbins and Amanda Colley knew The defendant was there, he was armed, he was shooting, and their deaths were inevitable. This is obviously evidence you've already heard and has been presented to you, and it will be argued in accord with the law at the end of this case. The fourth aggravator that applies to both Lindy Dobbins and Amanda Colley is that their murders were committed in the cold, calculated, and premeditated manner. And again, those terms will be explained to you legally, their definitions in further detail below, but essentially it means that the murders were committed after a calm and cool reflection, that they were committed with a prearranged design to kill, and with a heightened level of premeditation, which allowed for a substantial time for reflection. And all of that evidence has already been presented to you in the guilt phase. The extensive timeline we walked through of the defendant's words, actions, and whereabouts on August 27th explains to you and lets you know all of the time that the defendant had to reflect and to change his mind about the plan he put in place that day. And then obviously the fifth one that I mentioned, the domestic violence injunction that can only be applied as to Amanda's death, but you already have that injunction in evidence in this case, a certified copy of it that was introduced in the guilt phase to prove the charge of aggravated stalking can now be used in this phase to prove the aggravator related to the domestic violence injunction. At the conclusion of this phase of the trial, you will find that all of the evidence the state has already put before you proves each and every aggravator beyond a reasonable doubt. The aggravators will substantially outweigh any mitigation put before you in this case. And I don't know exactly what mitigation or how many mitigating circumstances may be put before you, but I suspect it may be larger in number than the 4 or 5 aggravators that the state will prove to you. But the judge will instruct you at the end of this case that this is not a simple task of math. You don't count up 4 or 5 over here and a tally of mitigating circumstances over here and just do a mathematical equation. That's not what you're here for. This isn't an easy task. It's important work. But what you'll be instructed to do is assign weight to those aggravating circumstances and any mitigating circumstances that have been proven to you. And you're going to be asked to weigh those against each other in reaching your conclusion. Once you have had an opportunity to do that, we are confident that you will find that any one of our aggravating circumstances will outweigh any potential mitigation put before you. Nonetheless, the aggregate of all 4 and 5 of our aggravating circumstances. It is that time we will ask you, after serious reflection, deliberations, and weighing all of this evidence, to return a verdict of the death penalty in this case. Thank you.
Mr. Wood, you may proceed with your opening statement.
Thank you, Your Honor. Good morning, ladies and gentlemen. Thank you for paying close attention to this case throughout the guilt phase, throughout every proceeding in this case. We know it's been difficult, a very, very serious set of circumstances, very serious case to deal with. And we respect your work and your consideration in this case and your obligations to follow the law. This is the most consequential decisions that you're going to have to deal with in this case. You should know that you will be instructed in this case, at the end of this case, that at no time do you ever have to, or are you going to be compelled to render a verdict for the death penalty. You're going to hear testimony that will last for a couple of days. But now we're at the phase where you have rendered a verdict in this case, and we're dealing obviously with the first degree murder counts, the 2 counts. And simply put,
having found Mr. Colley guilty of those 2 charges, we now have to decide, you now have to decide, what to do with Mr. Colley as far as the appropriate sentence in this case. You have always, in this case, throughout this penalty phase, throughout your deliberations, the legal opportunity to render a verdict of life in prison. Now, this process, as the judge has already told you about, is a different process than as you went through with what we in our vernacular call the guilt phase, where you were required to render a unanimous verdict in order for there to be a verdict in this case. And you've done that with counts 1 and 2, the first degree murder cases. However, in this process, and at the end of this case, you get your own vote. You get your own individual determination as to what the appropriate sentence in this case. And we're going to get into more detail about this and as part of the closing argument in this case, and go over the evidence with you and talk about the law that His Honor will instruct you on. But always keep that in mind throughout these proceedings, that you are entitled to hold on to your own decision about the appropriate sentence in this case. And that will be life in prison without the possibility of parole. And I'll discuss with you at the end of this case the significance of that. In other words, Mr. Colley, if that's the sentence that you impose, will leave prison in a pine box. There'll be a number of things that weigh in his favor in determining life without the possibility of parole. First, keep in mind that, as His Honor has already outlined for you and will also instruct you at the end of this case, the state is limited as to what they can present and argue in favor of the death penalty. Those are the aggravating factors that Ms. Dutton outlined for you, which you must consider or will consider and give whatever weight you decide to give, and determine for yourself if those factors have been proven beyond a reasonable doubt. That will be your individual call on that. But the state is limited to those aggravating circumstances. However, that's not true with the defense. We're going to present to you what are called mitigating circumstances, things that we will argue to you and show you weigh in Mr. Colley's favor in supporting a sentence of life in prison without the possibility of parole. And those factors can be limitless. There may be things, and actually I will argue to you and talk to you at the end of this case, some of the things that you already have heard in the guilt phase about how this happened and some of the things that led up to the tragic events of August the 27th of 2015. There are a set of laws too, or instructions that you've given that the judge has already outlined for you, which is contrary to aggravating factors which have to be proven beyond a reasonable doubt. We never have to prove our mitigating circumstances any more than what we call the greater weight of the evidence. So 51%. More likely than not, these circumstances have been proven. So our burden on that is much less, far less than what the state's burden is on proving their aggravating circumstances. And mitigating circumstances can be things that we'll talk about as far as how this happened, some of the things you've already heard about, the difficulties that were going on prior to the homicides. But you're going to be introduced to a number of folks that know Mr. Colley very well and will speak very highly of him. He is, after all, a human being. Mr. Colley is 38 years old. He has 2 minor children that you heard, I think, a tad bit during the guilt phase. His son, Trey, we'll hear more about him. and his daughter Avery. Mr. Colley was born in Illinois, in Elgin, Illinois. Came to Florida as a child with his family. You probably have figured out because Crystal Colley and Rhonda Colley testifying. He has two sisters. So you've already seen he has two sisters, and we're going to have a great deal of more testimony about family background from testimony from Crystal. JR, as we call him, is the youngest of the three. That when he moved from Illinois, he came to Florida. He went to school in his younger years in Orange Park. Eventually, his family moved to Volusia County. He actually graduated from Seabreeze High School in 1999 in Volusia County. You're going to hear from co-workers and other folks that Mr. Colley's been a very good employee, a very loyal employee, that he helped mentor other fellow employees. Mr. Colley, for the last 12 or so years, has been in the banking mortgage industry, and you'll hear a great deal about that testimony. You'll hear that he's been obviously gainfully employed for a long period of time. We'll get into more information about that for your consideration. That he did charitable work while he was in employment. You already heard, I believe, through the gift phase indirectly, that Mr. Colley worked at Citibank at the time of this incident and had been working there for a number of years, again in the mortgage department. That he has is very close to his family. He has living his mother and father. His mother is Judy Colley. His father is severely disabled. We call him JT, but it's James Colley Sr. Both of those folks live in Ormond Beach. You'll hear about how he's doing, Mr. Colley's doing, since he's been incarcerated in September 2015. That he's been pretty good about adjusting to everything, and in his incarceration, he's actually taking courses on becoming a paralegal. You're going to hear that. You hear a lot of information from various folks that Mr. Colley adored his children, adores his children, was very active in their upbringing, played with them, did things with them, took them on vacations, a whole host of things. You'll see some pictures actually that will cover this issue as well. Mr. Colley not only adored his own two children, but he was also very involved in his neighbors' children, kids in the neighborhood, just adored him and played with him, and he was constantly active with them. You're going to hear that Mr. Colley was a race car enthusiast. He had his own race car. He was involved in that. He was very active in coaching football and baseball with his kids and with other kids certainly in the community as well. That you'll hear of, now, Mr. Colley certainly is not a perfect person. You're going to hear testimony through experts and from his sister that Mr. Colley is a binge drinker. Has been for a long time. That oftentimes when he drinks, he keeps drinking. You'll be allowed to consider that in weighing the mitigation in this case. You're going to hear testimony that when on certain occasions, not often, but he has done cocaine. Matter of fact, the night this all happened, he did a couple of lines of cocaine with another friend earlier in the morning, and I'll talk about that in just a minute. That at the time of this incident, that in fact he was substantially impaired at the time of the shootings. And let me kind of go into that a little bit. You're going to hear more about what happened in this case from some sources, some expert witnesses. Basically, the evening before all this happened, on the 26th of August of 2015, Mr. Colley, as you know, was staying with his sister Rhonda. Rhonda was in Italy at the time with her husband on vacation, but Mr. Colley was staying at Rhonda's house. So too were Mr. Colley's parents, and also a woman by the name of Tammy Folsom, who was a housekeeper, a good friend of the family, was there. Mr. Colley, as he's done a million times, his children were there. He was playing, taking care of his children. Children go to bed. As I say, his parents were there. Mr. Colley then makes arrangements and goes and meets with a friend over in Orange Park and has several drinks there in Orange Park. And that on a couple of occasions in the early morning hours of that, now we're into the 27th, he did a couple of lines of cocaine with his friends. He's away from the children, he's over in Orange Park. As you know, we've already talked about Rhonda Colley's house was on Garrison Drive. So that happens. Then he leaves his friend. You already know the circumstances of him about 4 o'clock in the morning, going to his wife's house, going inside, discovering the items that were discussed in the guilt phase, had contact with Mike Dickens, had another beer, and then goes home. What you're also going to hear, give me just 1 second, I apologize. What happens when lawyers talk too much. What then happens, what you should know, is at the time that this all happened, the day this all happened, Mr. Colley was on a number of medications. At the time, he was being treated for depression and had been taking a medication called Wellbutrin. But about 2 weeks before this happened, his doctor switched medication, had him go on Cymbalta to deal again with the depression. That was about 2 weeks before this happened. Also at the same time, about 2 weeks before these tragic events, because of some sleep problems that Mr. Colley was taking, he was prescribed Ambien. And he took it as needed, not every day. But when he gets home from Mike Dickens, he knows he has to go to court in the morning. He's been up all night. He takes 2 half tabs of his prescribed Ambien, and then tries to get some sleep. He's woken up a couple hours later by his father, who again is there at the house. So he has to go to court, gets up, goes to court, and then you know the events that unfold. What's going to be significant that we'll show you is the effects of the Ambien that are well documented, and you'll hear expert testimony on this, that you're going to hear the word parasomnia, which is that the Ambien is known to, and did in this particular case, cause Mr. Colley not to remember and not to be able to perceive and deal with, from a mental health perspective, the things that were going on that morning, including court, and the events as they unfolded in this case. We're going to have, for your consideration, 3 experts, 2 of which are going to specifically deal with the medication issue. You're going to hear today Mark Mills, who's a psychiatrist from Chevy Chase, Maryland, who has evaluated personally Mr. Colley, is an expert in psychiatry. He's going to talk to you about the issues of Ambien and the other medication he's on, which actually, too, I failed to mention that Mr. Colley, because of some severe back problems, back then he was on a number of pain medications, oxycodone, Mobit, Flexeril, and the like. And so there's going to be some discussions about those medications as well, too. But he's going to testify based on the series of events and some very particular mental health issues that Mr. Colley was substantially impaired at the time of the shooting. And that will be for your consideration. We'll be calling, you'll see him tomorrow morning, Dr. Daniel Buffington, who's an expert clinical pharmacologist, who is going to get more in depth about the various medications that Mr. Colley was on and the effects of Ambien, the known adverse side effects with regard specifically to Ambien that he had taken that morning. So these are things that we're going to be getting into as well. You're also going to hear from a third expert, I believe by the end of today, Michelle Quiroga, who's a neuropsychologist from down south in Coral Gables, who's going to talk about other aspects about Mr. Colley's mental health, that he obviously had been suffering from depression, he had issues of anxiety, that she's going to talk about his chronic alcohol abuse, and the issues with regard to his abuse of cocaine, and some other factors as well too. So that will be before you for your consideration. You're also going to hear, unfortunately, some testimony from Crystal that when Mr. Colley was a child, he witnessed his mother take a baseball bat to his father in his presence. You'll hear that on another occasion, that his mom put a knife to his father's throat, again as a child. And that Mr. Colley was subjected to witnessing domestic violence in the house. These will be amongst many things that you'll hear, and we'll talk about at the end of this case the significant mitigation that you're going to hear. But we'll also ask you to keep an open mind and understand that at no time will you ever be compelled under the law to render a sentence of death. We're on the other hand going to be asking you to individually determine that the appropriate sentence in this case is life in prison without the possibility of parole. Thank you.
Thank you, Mr. Ward. That now concludes the opening statements of the attorneys. State all your first witness.
Can we get a pressure on real quick?
Sure. Proceed with some of the testimony in the state's case. I'm going to read you an instruction. You are about to hear evidence about the impact of this murder on the family, friends, and community of Amanda Colley and Wendy Dobbins. This evidence is presented to show the victims' uniqueness and as individuals and the resultant loss by Amanda Colley and Wendy Dobbins' death. However, you may not consider this evidence as an aggravating factor. You may hear from a couple of folks in that same area of testimony, and I'm going to give you that same instruction before any of those folks testify. All right, State, call your first witness.
Thank you, Your Honor. State will call Tammy Malone.
And Judge, we had previously indicated to court that we do maintain our objection to the victim in a statement that the court's going to now put witnesses that are attended.
So there you go. Ms. Malone, if you'll take a witness, stand right here. Right up here. We'll have you remain standing when you get there, so the clerk can administer the you raise your right hand, please.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Thank you, Ms. Malone. You can be seated. Ms. Dunn, you may proceed with your report.
Thank you. If you would, ma'am, please introduce yourself to the jury and let the jurors know how you're related to Amanda Colley.
I'm Tammy Conacher Malone, and Amanda was my older sister.
And Your Honor, at this time, State will introduce States A, I believe, without additional objection by the defense.
Now be received as State's next number exhibit.
May I approach, Your Honor?
You may.
Ms. Malone, I ask you, if you would read a statement that you had prepared for court today.
I had one sister, one person who had the same parents as me, one person in the world who came from the exact same place as me. She was my person. The person that I could talk to about anything, and he took her from me. To my mother's youngest child, my mother, one of the kindest, most gentle creatures that God ever created. And I've watched her struggle with the pain of this loss for 3 years now. My whole family's been broken by this one person and his horrible actions. Where before we were all secure and saying, bye, love you, see you later, now we know that evil can strike at any time, any place, and from any direction. I asked my sister's children, what do you want people to remember about your mommy? My nephew Trey will be 9 next month. He says she was the greatest mommy in the world and he misses her. He misses going to the fort and the pool with her and that she taught him how to swim. My niece Avery just turned 7. She said her mommy didn't teach her how to swim, but that she misses seeing her beautiful face and how whenever Daddy did something mean, Mommy would love on them and hold them and make them feel better. Their lives have been forever changed, and now they have neither parent because of this man's actions. My nephew Dylan is 17. He wants everyone to know that she was a beautiful, loving, and caring aunt, and that he misses spending time with her and their weekend trips. My son Mikey is 18. He misses her, and how she would call every year on his birthday and very loudly sing happy birthday. The whole song, no matter where we were at, he knew that call was coming on his birthday if they weren't together. And also that losing her this way has made him realize that people aren't who you think they are, and not to trust everyone. She was smart, she was funny, she was kind, compassionate, and genuine. Her life mattered. It mattered to so many people in so many different ways, and he took that from all of us. She made friends everywhere she went, and she was genuine with it. There was no wondering about it. If she acted like your friend, she really was. She was loyal. She couldn't stand to see people upset or sad. She would do almost anything to make you smile. Like, seriously, anything. Whenever she had a disagreement with someone and they'd get mad and walk off, she'd follow them right behind them and then get in their personal space. and with this quirky little side smile and a raised eyebrow, and say, "You can be mad at me if you want to, but I love you, and I'm going to stay right here until we work it out." She was joy. Having her around was like having a piece of your childhood back. She had a way of making every little, everyday thing seem magical. It's difficult to put into words, especially 1 to 2 pages, how someone's life and loss of life impacts you. So I have one little story, and then I'm done. I was 8 years older than her. I got out of school at 2:25, and she got out of school around 3. So I'd be home whenever she got off the bus. One day, when Amanda was about 8 years old, she didn't get off the bus on time. So everyone's in a panic. Before anybody could make it home, she comes walking up. Wouldn't say where she'd been or what she'd been doing. Well, needless to say, that wasn't going over very well. So finally, she admits that one of her friends got in trouble at school and had to stay after her. And she didn't want them to have to walk home alone. So she stayed with them, and they walked home together. That's who she was as a child, and that's who she was as an adult. All that's left of Amanda are her children, family, and friends, and the memories that we have.
Any examination, Mr. Wood?
Yeah, you go.
Thank you, ma'am. State, you call your next witness, please.
State would call Beth Kennedy.
Judge, we maintain our objection to victim impact testimony.
So noted for the record, no rule. Again, folks, along with Kennedy's work, go ahead here. Again, you're about to hear evidence about the impact of this murder on the family, friends, and community of Amanda Colley and Lindy Dobbins. This evidence is presented to show the victims' uniqueness as individuals and the resultant loss by Amanda Colley and Lindy Dobbins' death. However, you may not consider this evidence as an aggravating factor. Thank you, Henry, for this, your hand.
Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
You can proceed.
Your Honor, other than the objection previously stated, I don't believe there's further objection to state admitting states B.
We received this as state's next number exhibit. You may proceed.
Thank you.
Good morning, ma'am. If you would please introduce yourself to the jury.
Beth Kennedy.
And Ms. Kennedy, how did you know Amanda Colley in this case?
We were college friends since 1999.
And did you prepare a statement for court here this morning?
I did.
Okay. Your may I approach?
Yes.
Ms. Kennedy, I would ask you to read your statement.
Thank you for allowing me the opportunity to address your court today. As a victim and a friend of Amanda's since 1999, these words have been nearly 3 years in the making and are crucial to my closure. At this time, I would like to provide you with a glimpse of how Amanda impacted my life as well as many others. Almost 3 years ago, we lost our friend, co-worker, neighbor, sister, daughter, aunt, and mother, Amanda Cloninger, in a horrific way. She was taken from us abruptly at 36 years old, the day after her son celebrated his 6th birthday with family and friends. Amanda was an extraordinary mother who made everyday situations magical and protected her children from experiencing a childhood that mirrored the tough circumstances she grew up in. She gloated in the fact, that she was chosen to parent Trey and Avery and stood in awe of the children she made and how they were growing up to be kind, respectful, and well-rounded children. She was so grateful for the opportunities that she was able to provide for them. Unfortunately, this time was cut short. Have you ever met someone who changed your life forever? For me and many of her friends, that person was Amanda. She was the epitome of the statement, a person who has never met a stranger. Everyone who crossed her path could instantly feel her warmth and sense her glowing personality. Amanda had countless circles of friends. She loved to dance. She had a singing voice that would give you chills, even when she would make up her own words to the songs. She was one of those people who could always make you feel like you were one of a kind. It was a gift. It was Amanda. In Amanda's eyes, everyone was flawless. She didn't care what color your skin was, how much money was in your bank account, or what mistakes you had made in the past. She accepted who you were and where you were in your life and was proud to call you a friend and have you in her circle. Again, it was a gift. It was Amanda. Our memories, our lives have holes in them now. There are so few memories that don't have some silly saying of Amanda's in them, or some thought of how she helped us, either financially or emotionally, or some anecdote she told that ended with our laughter and her snorting, which was an Amanda trademark. She had a way of cutting through tough situations with a perfect or perfectly hilarious thing to say, and we always left her presence feeling lighter and our stomachs hurting from laughing too much. I know I have never met anyone like Amanda before, and I'm afraid I will never meet someone like her again. Amanda wanted to continue to change the world. She wanted to go to law school and become an advocate for domestic violence. In the midst of all her personal chaos, she mentioned her future plans excitedly, like she had found her true calling at 36 years old. Amanda would have been excellent at helping women who have been made to feel that their voice doesn't matter or isn't worthy. She had a gift of making everyone instantly feel at ease, and that would have been her greatest strength for women who had spent a lot of time living in fear. Even though Amanda is not here on earthly terms, her legacy and memories have not died. Not a single day passes that I don't reach for the phone to call or text my sweet friend, to share a silly story or to ask for advice. When I start feeling sorry for myself, I begin to think about her precious children and what they have endured thus far and how their everyday life is impacted by the choices of their father. Her son will reflect back to his 6th birthday, but he will always remember that his loving mother died violently the day after. And her daughter will never know what it feels like to have her mother take her prom or wedding dress shopping. Each night, try and they replace their lips to a picture of their mom. Their mama will never be able to wrap her children in her arms for us. We want you to know and feel what our lives are like without Amanda, and to realize how joyful our lives would be if she was still here. Please think about Amanda and all of the lives she has blessed.
Thank you. Any questions, Mr. Wood?
No.
Thank you. State for next witness.
State would call William Mosler.
Again, folks, you're about to hear evidence about the impact of this murder on family, friends, and community of Amanda, Colley, and Lindy Dobbins. This evidence is presented to show the victims' uniqueness as individuals and the resulting loss by Amanda, Colley, and Lindy Dobbins' death. However, you may not consider this evidence as an aggravating factor. So, raise your right hand, please.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Mercer. You can be seated.
And judges, we have before, we respectfully maintain our objection to the commitment.
So, for the record, you may proceed this time.
Thank you. Without additional objection, I believe at this time the state would introduce State C without further objection.
Now that you see the state's next number exhibit.
Good morning, sir. If you would, please introduce yourself to the jury.
I'm William Mosler. I'm Lindy Mosler Dobbins' father.
And did you prepare a statement for court here this morning?
Yes, I did.
Okay, I'm going to ask you at this time to read that statement.
My name is William Mosler, and I am the father of Lindy Mosler Dobbins. This letter is an open letter from our family. Our family did not lose one person in this tragedy. We lost a daughter, a sister, a wife, a mother, a niece, a cousin, and a friend. Lindy was the heart of our family, the one who kept us together, our glue. Words cannot describe what is missing and what we will all miss for the rest of our lives. She was the one you could all depend on, no matter what you needed. A laugh, a shoulder to cry on, or a kick to get you going. When things got tough. She took the world on her shoulders. Lindy was always there to make sure everyone was okay. Lindy was our family member who never forgot a birthday, anniversary, or holiday. She made everyone she knew feel special. And she had a special presence that brought people together. One of the most unselfish people that we knew. Our lives have ever or forever changed. She got us through divorces, births, deaths, and family vacations. She touched everyone she met. She befriended and helped everyone whose path she crossed. If you needed something, she just knew and did her best to help. She was always helping family and friends through crisis, babysitting friends' kids and volunteering for her son's t-ball team. Lindy's children have had their mother taken away. She will never see her children graduate or get married. Lindy will never hold her grandchildren. Over the last 3 years, we have suffered like no family should have to. We have lost our security, and none of us feel safe anymore. Our family worries all the time. We have nightmares. We will never be the same people we were before Lindy was taken from us. We will forever miss our glue. The community has lost a caring mother who taught religion classes and was a room mother. She positively impacted numerous children in St. Johns County. Our lives have been forever changed over one selfish act, and has taken away the heart of our family.
Any questions, Mr. Wood? Thank you, sir. State call your next witness.
All right, this time state would call Chris Dobbins.
And again, Your Honor, we respect Lindy to the victim impact.
So that the record overruled. Again, ladies and gentlemen, you're about to hear evidence about the attempt of this murder on the family, friends, and community of Amanda Colley and Lindy Dobbins. This evidence is presented to show the victims' uniqueness as individuals and the resultant loss by Amanda Colley and Lindy Dobbins' death. However, you may not consider this evidence as an aggregating factor. Thank you. Could you raise your right hand?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Mr. Dobbins, you can be seated.
Thank you, Your Honor, and without additional objection, Your Honor, at this time, I believe the state would introduce States D.
Received as the state's next member exhibit. You may proceed when you're ready, Ms. Dunn.
Thank you. Good morning, sir. If you would introduce yourself to the jury.
My name is Chris Dobbins, and Lindy was my wife.
Okay, and how long were you and Lindy married?
12 years.
Okay. Did you prepare a statement for court this morning?
I did.
Okay, I'm going to ask you. Read that here.
Wife, mother, daughter, sister, niece, friend, co-worker, volunteer, acquaintance. Just some of the ways that so many people knew and will remember my wife, Lindy Dobbins. Again, my name is Chris Dobbins. Lindy and I were married for 12 years and raising our 3 children, Christopher, 16, Ava, 10, and Patrick, 9, in the Murabella neighborhood before she and her friend Amanda were brutally and senselessly murdered by the defendant on Thursday morning, August 27, 2015. After 3 years, I'm still unable to describe my feelings that morning as I received a call from the St. Johns County School District at 11:41 a.m. stating Ava and Patrick's Elementary School was under a hard lockdown due to criminal activity in the area under the direction of local law enforcement. Obviously not a phone call anyone expects to receive. I immediately started calling and texting Lindy to find out what's going on, but she never answered her phone or replied to any of those texts. I called the Croc store at the St. Augustine Outlet Mall where Lindy worked, only to be told that she had left work early that morning to go help one of her friends. In a panic, I walked out of my meeting, went to my car, and started driving home. I tried calling Lindy a few more times, but she never answered. I tried calling Mill Creek Elementary, only to be told that the school was still on hard lockdown. I started searching Find My iPhone to see where Lindy's phone was, and it showed her phone was at Amanda's house. I pulled into our neighborhood, Marbella, and as soon as I turned right onto the South Bellagio Drive, I had to park my car because the road was blocked by several cars further down. I walked down the street, saw police tape blocking the road, told an officer standing by there, by my wife's phone and her car were at the house at the end of the street. He asked for my name, and after a few minutes I was introduced to Detective Samantha English, who shared with me the most horrific and unforgettable words I've ever heard. My wife Lindy and her friend Amanda were shot and killed in Amanda's home, and they were still searching for the defendant who fled the scene. After some time and many phone calls to our family to share this unimaginable news, I was driven to Mill Creek Elementary, which was still under lockdown, to bring my children home and share with them this horrific news. Knowing how difficult and unbearable it was for me to hear what Samantha shared with me, now I had to find a way to tell Ava and Patrick. The questions started immediately when they walked them down to the office. What's going on? Why didn't Mommy pick us up? Who is this lady with you? Why did we get to leave school first? Why are the gates locked? And so on. Just trying to keep my composure while not saying anything until we got home. We walked in our front door, sat on our couch in the living room, and I told the kids that the school was locked down today because there was a terrible accident with Mommy and Miss Amanda, and Mommy died. The worst possible thing I could ever imagine having to say, and I'm having to say it to my 9-year-old son and 10-year-old daughter. This was just the beginning of the life-changing, lifelong challenges and hardships we would face together, all because of the irresponsible decisions and actions of the defendant on that Thursday morning. Lindy was a loving and caring wife and mother who enjoyed spending time with our family and friends, and was always the person who'd bring people together. When we moved to St. Augustine without knowing anyone in the area or having any family close by, Lindy created a neighborhood mommy group to host events that would bring mothers and their children together at the pool, playground, at our home, to meet new people and to make new friends. She also organized neighborhood events to meet new people, help new residents feel welcome moving into our neighborhood, and this is how she met Amanda and they became closest of friends. Lindy was always active at the kids' schools, routinely volunteering for events, being a room mom, chaperoning field trips, meeting kids for lunches during the school day. She was also actively involved as a volunteer for Ava's neighborhood swim team and was the team mom for Patrick's baseball teams for several seasons. All of those vacancies that must now be filled by others because Lindy was taken from us way too soon. And although she was not Christopher's mother, they developed an incredibly close relationship over the years. And even more so when Christopher moved in with us during his freshman year in high school. Lindy was even the one who pushed him to get his permit because he was extremely hesitant and took him driving to practice for his test. But again, because she was taken away from us too soon, she was not with us to see him get his driver's license. But I know Christopher was inspired by her when he passed his test. We would spend weeks every summer traveling home to Buffalo, New York, spend time with family and friends, making several stops along the way to meet up with family and friends that we have known and met over the years. Every day of vacation was filled with something to do, people to see, places to go, because Lindy always wanted to spend as much time as possible with family and friends. She was the life of any party with her welcoming smile and enduring laugh, which are just two of the things we will never see or hear again. I'm sure there's an endless number of people who could come up here in front of you and speak about Lindy's compassion, understanding how caring she was, but I think nothing speaks louder than her actions on that morning of August 27, 2015, although I know her support of Amanda didn't just start that day. She was one of Amanda's best friends, one of her supporters, a confidant that Amanda loved and trusted. And even though she knew of the challenges Amanda was facing and that Lindy was putting herself in harm's way, she never hesitated to respond to Amanda's needs immediately that morning to support her through her most difficult time. Of course, I wish Lindy wouldn't have answered that call that morning, left work that morning, or gone to Amanda's house that morning, but Lindy has never been someone to turn away a friend in need. At the beginning, I spoke about how Lindy was a wife, a mother, a daughter, a sister, a niece, a friend, a co-worker, a volunteer, and an acquaintance. I've been able to share just a glimpse of what Lindy represented to us as a wife, a mother, and to Amanda as a friend. But what makes her loss even more impactful are all of her relatives and the countless number of people that have known or met Lindy during her short 39 years here that will never get to see her, speak with her, or laugh with her ever again. This life-changing event not only took away two beautiful, loving, caring mothers from her family, but it took two incredible women away from everyone I have ever met and prevented them from having a positive impact on the lives of countless others. When people experience a loss or a tragic event, you hear them talk about getting used to their new normal. Well, here's a look into what our family's new normal is like since Lindy's death. Lindy's birthdays and Mother's Days are celebrated by releasing balloons at the Memorial Park in Mirabello that was dedicated to Lindy and Amanda shortly after their deaths. Holidays are not celebrated with the same joy and enthusiasm they were in the past. Little League baseball games are attended with an empty blue chair. For Lindy to sit in and watch Patrick play. Ava's swim team t-shirts were designed with a Swimming for Lindy logo to remember Ava's mom. The kids' birthdays are celebrated with an empty seat and void that will never be filled. Lindy was not there for Ava and Patrick's elementary school graduations. Christopher missed out on having one of his biggest supporters at his high school graduation and being dropped off at his dorm for his first year of college. Lindy is missing at every hockey, football, and baseball game that we attend as a family. Free time we may have had before is now spent at therapy sessions and support groups. Volunteering at sporting events has been replaced by volunteering at domestic violence centers. There are no more hugs, kisses, or laughs shared. There's a sense of fear and insecurity that lingers, knowing that someone can act so heinously. On my way home, see you soon, or I love you, are words I'll never hear from Lindy again. I think I've given you just a brief glimpse into who will truly be affected for the rest of their lives by the acts of violence that occurred on that morning of August 27, 2015. Thank you for allowing me the opportunity to share what Lindy meant to me, our children, and to everyone who knew her, and the significant impact her loss has had and will continue to have on all of our lives.
Any questions, Mr. Williams? Thank you, sir. Any further witnesses by the state?
No, Your Honor.
Please announce the rest at this time.
Yes, Your Honor.
Ladies and gentlemen, you just heard the state announce it's resting its case in chief for this portion of the trial. That's all the evidence and testimony we hear in the state's case in chief for this portion of the trial. We're going to go ahead and take our break at this point. It's 10:20, so I'll have you again do the second floor jury lounge. If you want to step outside and get some fresh air, that's fine. Let's plan on being back at 11:45. That'll be 10:45. So be back in the jury lounge at 10:45. Again, as I instructed you during the earlier phase of the trial, please do not discuss this case with anybody during the break, amongst yourselves or with anybody else for that matter. Don't do any research of any type. Leave your notes here in the courtroom, and again, 10:45, we'll see everybody back here. Thanks, folks. courtroom, then we'll leave the courtroom until we get a signal from the deputies that it's clear. Anything we need to take up before we break? Mr. Wood? Anything we need to take up before we break? State?
No.
All right, we'll be in recess until 10:45. Again, everybody remain in the courtroom until you're cleared to exit the court. into our jury room. Mr. Wood, you ready to go?
I am.
Okay. Mr. Gray, you can bring the jury in, please. Thank you. Welcome back, everybody. Y'all be seated for getting situated. You call folks, so we left off the statement rested its case in chief. We'll now begin with the defense presentation of its case. Excuse me. Mr. Wood, you can call your first witness.
Thank you. Dr. Mark Mills.
Dr. Mills, if you'll take the witness stand up here and remain standing when you get there, I'll have the clerk administer the oath. Later on. Thank you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Now, if you can take a seat.
Thank you, Your Honor.
Mr. Wood, you may inquire when you're ready.
Thank you. Good morning, Dr. Mills.
Good morning, Mr. Wood.
If you'll start us off and give us your full legal name for the record.
Sure, it's Mark with a K, John, John, Mills, Mills.
And what do you do for a living, sir?
I'm a psychiatrist, but I practice mostly as a forensic psychiatrist, which is to say that mostly I evaluate people and then testify about their mental states.
And how long have you been, well, first of all, are you a licensed psychiatrist?
Well, in most states, you're a licensed physician, and then you may choose to become a psychiatrist by doing a residency and taking boards. But I'm a licensed physician in Maryland and in Nevada, and previously in California, Massachusetts, and in D.C.
And when did you first start your career as a psychiatrist?
Well, I graduated medical school in '75, so and my residency in psychiatry began then. So for the next 3 years, I was a resident and chief resident in psychiatry at Stanford University Medical School.
Okay. And if you could kind of go forward from there and tell us about your work background.
Sure. I mean, it's relatively straightforward. I was on the junior faculty at Stanford for 2 years, running the psychiatric evaluation unit of the Palo Alto Veterans Administration Medical Center. I did that until about 1980. Then I moved to the Boston area, joined the faculty at Harvard, was the intake supervisor at Massachusetts Mental Health Center, was the chief officer, which sounds very grand, but it was not like a CEO. It was really kind of a glorified administrative job. And as I mentioned, I began teaching at Harvard. I then became the Commissioner of Mental Health for the Commonwealth of Massachusetts. I had 32,000 disgruntled, underpaid, rather dedicated workers. It was a really very impressive agency. Then I returned to California and was the Chief of Psychiatry at the West Los Angeles Veterans Administration Medical Center, which was then, at the risk of bragging, the largest psychiatric hospital in North America. We had about 400 plus inpatient beds, 200,000 outpatient visits a year. I was then the Director of Program in Psychiatry and Law at UCLA, and first an associate and then full professor there. At that point, I had my first child, Henry, coming along, and I decided I needed to get a day job that would help support the family. So I became a full-time forensic psychiatrist.
Okay. And when would that have been?
That was 1987.
Okay. And so where do you currently practice? Where's your office at?
My residence and office is in Bethesda, Maryland. And I guess you can do the math as well as I, but a full-time forensic psychiatrist for 31 years now.
Do you also have a law degree?
I do.
When did you get your law degree?
1970.
Okay. And from where?
Pardon?
From where?
From Harvard.
Okay. Okay. And you're still full-time practicing in?
Full-time.
Okay. All right. So let's talk about the difference. What's the difference between being a psychiatrist and a psychologist?
Well, oftentimes there's very little difference. I think as a group, psychologists are better versed in psychological testing, and in some cases, in certain kinds of therapy, as a group, psychiatrists are allowed to prescribe medications. In a couple states, psychologists can do that, but generally, psychiatrists are more tuned in to medical issues that can affect patients.
Okay. You mentioned the word forensic psychiatry, forensic psychiatry. What does that mean?
Well, forensic just means of or pertaining to rhetoric. It's come to mean legally related. So forensic pathology are the people who say, you know, how somebody was injured or worse, killed. Forensic psychiatrists are those people who testify about mental states in whatever context it's relevant. It can be a criminal matter like this. It can be a matter of testamentary capacity. Did Aunt Joan have the capacity to make out that will as she did? And it can be a variety of civil suits. I mean, think about the Las Vegas tragedy, where many people were killed, or many people injured as well from the shooter. Well, those people have now, or many of them have brought suits against MGM, and MGM actually has recently gone into court to say they can't do that, but ultimately their mental state, their injury, probably be relevant.
Okay. So have you testified previously in psychiatry, in the field of psychiatry, as an expert?
Many, many times.
Would you be able to give the jury an idea of the approximate number of times you've testified as an expert?
I would say probably more than 500.
Okay. Would that be in criminal cases, civil cases, both?
Both. It's roughly half civil, half criminal. About in the criminal arena, it's about half for the defense and about half for the prosecution. It's probably more in federal court than in state court, but I certainly appear regularly in state court.
Okay. Have you ever testified as an expert previously in the state of Florida?
I have.
On more than one occasion?
Yes.
Okay. Would that be state, federal, both?
Both.
Okay. Would that be civil, criminal, or both?
Both.
Okay. Have you testified in death penalty cases before?
Yes.
Okay. And when was the last time you provided testimony as an expert in psychiatry?
2 weeks ago in federal court in Miami.
Okay.
I guess maybe 3 weeks ago now.
Okay. All right. All right. So let's. Let me ask you this too. In the times or the occasions that you've testified as an expert, have you been privately retained or testify for on behalf of or paid by the government, or how does that work?
The answer again is both. It generally is, one's better compensated when one is privately retained, but many important cases, one of the parties, particularly the defendant, may be indigent, and so often I testified on behalf of state agencies or some kind of public agency.
Okay. And what is your rate in this case?
I think it's $300 an hour.
Okay. Now, let's talk a little bit more about this. We'll talk about this case. How and when did you first start becoming involved in this case?
Well, Mr. Shoemaker's office contacted me probably in, I should remember better, but I began working on the Colley matter in October of 17, and I think I was contacted probably in May or June of that year.
And did there come a time when you agreed to provide expert assistance in this case?
Yes.
Okay. Would that have been shortly after Mr. Shoemaker had contacted you?
Within a few weeks, yes.
Okay. And in the course of your involvement in this case, did you have occasion to receive police reports, statements, things along those lines?
Yes.
Okay. And did you at any time receive Mr. Colley's prior medical records?
Yes, I did.
And did those include pharmacy records?
Yes, they did.
Okay. And you were able to review those as well?
I did.
Okay. And at some point, did you actually come to sit down and meet with Mr. Colley himself?
I did. I met with him pretty much the entire day of October the 4th of last year, of October the 5th of last year, and then I spent about a morning plus with him on October the 6th of last year.
And did you also at any time receive any records from a Dr. Daniel Buffington?
Yes, sir.
And who do you know him to be?
I know him to be a pharmacologist of some considerable stature.
And in the course of your involvement in this case, did you come to review materials, records that Dr. Buffington sent to you?
Yes.
And were those also likewise part of your consideration, your evaluation, and rendering certain opinions in this case?
They were.
Okay. Now, in the, well, let's, before we get into the meat of Mr. Colley's information provided to you, if you could tell the jury what medications Mr. Colley was taking. Well, let me break this up. In your review of the pharmacy records, was Mr. Colley taking various medications that were prescribed for him in August of 2015?
Yes, he was.
All right. And could you tell the jury what those medications were?
I think I have most of them at least. He was taking 2 different antidepressants. One that had been prescribed in the beginning of August, Wellbutrin, and then that was later changed to Cymbalta. These are the brand names. He was taking a sedative hypnotic called Ambien. That turned out to be quite important. He was taking and had taken bupropion. And
What is the generic word for that?
Wellbutrin. And it's used as an antidepressant and as a medication to help people stop smoking. And
Before we go on, Doctor, for the benefit of the record and perhaps for the jury as well, is Ambien known as, that's a commercial name for what medication?
I'm going to mess up the pronunciation. I always call it Ambien, Zolpidem.
Zolpidem?
Yes.
Okay. Okay, I'm sorry, I cut you off. What were the other medications he was
Well, he
taking?
was on one of several preparations that included an opioid medication. So he was on hydrocodone, and I can't recall, there's another one, but essentially potent analgesics for neck and muscle problems that he had had, and he took those on a fairly regular basis.
Would one of them be Mobic?
Mobic is it's a potent analgesic as well, but it doesn't contain opioids.
Okay. Now, and those medications were for what condition?
Well, let's run through. The Wellbutrin and the Cymbalta were, as I mentioned, antidepressants. The bupropion as well, although it can be used, it was not used here as an anti-smoking drug, it can be used as a sleep-inducing agent as well. The hydrocodone and the Mobic were used as analgesic medications to help his pain. The Ambien was used to facilitate sleep. And then he took a variety of over-the-counter preparations, LipoRush, Tonlin sensor, medications I'm not particularly familiar with, but Dr. Buffington elicited a good history of those and their usage.
Okay. Do you recall if he ever took the medication Flexeril?
No, I think he took that too. That's another non-steroidal anti-inflammatory. It looks sort of like Aleve or Advil, only a little more potent.
Now, you're a medical doctor. Can you prescribe these medications?
Yes.
Okay. And are you familiar particularly with the drug Ambien?
Yes.
All right. Are you familiar with the known adverse side effects of Ambien?
Yes.
And generally, to your knowledge, what are the known adverse side effects of Ambien?
Well, there's a phenomenon called parasomnia. Para meaning around or about, somnia meaning sleep. And the most common parasomnia for most folks is sleepwalking. But there's sleepwalking, there's sleep talking, there's sleep sex. There are a variety of conditions where people act seemingly in a rational or okay way, and yet when you later talk to them, they have no recollection. That is a dense lack of memory about what occurred, or how they were feeling, or how they were thinking. So that is the phenomenon of parasomnia, and Ambien is probably the drug most associated with people who have that potential, having parasomnias. It's also associated with memory blackouts or loss of memories more generally, even when nothing unusual occurred or when something untoward occurred. I think I said in my deposition testimony that I had a colleague and friend who fell down an escalator in Honolulu Airport. And this is a woman who was then in her late 70s, and she badly tore up her leg. Fortunately, her husband was there. Paramedics were called. They treated her. She was able to get on a plane. But the next day, she had no recollection of her injury whatsoever, except the pain and the bruising that she saw. So that's a kind of parasomnic event as well. Parasomnia meaning, again, around sleep or sleep associated, but particularly loss of memory.
According to the records, Mr. Colley's records, when was he prescribed the Ambien medication in August of 2017?
I believe that was in early August, that's my recollection.
Okay. And, okay. So when you met with Mr. Colley, that would have been at the St. Johns County Jail, is that correct?
Yes.
Okay. And did you, in order to render an opinion in this case, did you take into consideration Mr. Colley's information that he provided to you when you were meeting with him?
I did.
Okay. And did that information include Mr. Colley's recounting of what happened during the evening of August 26th throughout the morning and later morning of August the 27th of 2015?
Yes.
All right. And using that kind of a time frame, can you describe or tell the jury the information that Mr. Colley provided to you regarding that series of events during that time frame?
Well, I mean, we can talk generally about that time frame, or we can talk more specifically around later in the morning and later still. I mean, he had worked that day, he came home from school, it was his son's birthday party, as I recall. I mean, he told me a number of things that sounded pretty much like a typical evening for many folks. He went out with a buddy of his, he had some drinks, he probably around 1 in the morning did a line of cocaine.
Let me just kind of stop you there, and I want to make sure I break this down and cover it for the jury. When he, at the time that he was, or by the time he was meeting with a friend, was he with his children at that time?
No, he met his friend, I think, around 11, is my recollection. And his children had gone to bed, their young children, or were then at least, had gone to bed around 9, so they were.
According to Mr. Colley, do you remember if he said if there were other people at the house when he left?
Yes, there were.
Okay. And so he left the house, he meets with a friend. Do you recall where he met with the friend at?
It's in my notes, but I think he met at a bar and then they went to another bar, is my recollection.
Okay. And you said he had been drinking. I'm assuming we're talking alcohol?
Yes.
All right. And did Mr. Colley say how much alcohol he had?
Sure. I mean, I, of course, asked that because obviously alcohol affects mental state, so it's a relevant question and an important one. And he had had several drinks at home and had several drinks with his friend, and even later, so he had drinks probably till about 3 in the morning.
Okay. And did he say beer, wine, mixed drinks? Do you recall any specifics about that?
I recall mixed drinks in the early evening and beer later in the evening.
Okay. And then, so he also told you that he did a line of cocaine?
Yes.
And
Well, he didn't, pardon me, he did a line of what he thought was cocaine. I don't know if it was or not.
Sure. And do you recall when Mr. Colley, what time frame Mr. Colley provided that information?
Yeah, it was around 1 a.m.
Okay. And, all right. And when Mr. Colley had done the cocaine, was he still at the bar?
I don't recall the location. I'm not sure I asked him.
Okay. And, okay, so according to Mr. Colley, did there come a time when he parted company with a friend?
Yes.
And what happened then? What did Mr. Colley say then happened after that?
Well, I mean, then he went over to his estranged wife's home and was hoping to see her. She was not there. He had thought that she was there because she had apparently complained was not feeling well, and that's why she didn't come over and go over to Trey's son's birthday party. And he found some sexual toys, was, I think, quite upset by his recollection. So upset that he smashed, I think, 2 or 3 televisions, LCD kind of televisions. And then he left, came back, ran and went to another friend's house, talked to that friend briefly, may have had a beer at that point, and then came back to his sister's house where he was living.
Okay. So let's kind of stop there and kind of just freeze frame for a second. With regard to the cocaine, are you aware of, well, let me first ask it this way. Have you had occasions when you've conducted evaluations, examinations on persons who have, for whatever reason and what other different circumstances, have consumed cocaine?
Yes.
Okay. Are you, as an expert, familiar with how long generally cocaine stays in the system?
Well, it depends what you mean by that. If you mean how long is it psychoactively effective, that is it affecting mentation, I think if you do a line or two, the answer is 2 hours-ish. If you mean how long can it be detected by, gas chromatography, the answer is for a much longer period. But it's effective cognitively or emotionally for a couple hours.
Okay. So what you're talking about there, for the benefit of the jury, is there's a difference between the psychoactive effects on mental state cocaine, but which is different than whether you could test positive if you were drug tested or something like that.
That's right. And by analogy, if you have a couple drinks within a couple hours, probably the effects are substantially worn off if you're an experienced drinker. On the other hand, you can detect the alcohol in the blood system for quite a while.
Speaking of experienced drinking, did Mr. Colley, during your time with him, provide you any information with how frequently and how much he habitually drinks?
Yes, he did.
And what was that?
Well, he drank regularly and significantly most days. Not all.
Okay. And again, we're talking alcohol here for the benefit.
Yes.
Not talking Gatorade, but okay. Okay, so now we're at Mike Dickens, and at some point he leaves Mike Dickens.
Yes.
Okay. And the neighbor.
Correct. And comes on around 5.
Okay. And according to Mr. Colley, what then happens?
Well, now he's not surprisingly, having been up all night, pretty tired. He needs to get some sleep. He knows he has a court appointment the next day. He's wound up because of what he has seen at his wife's place.
Let me just stop you there. Sorry to interrupt. You say next day. You're talking about that same day?
Later that same morning.
Okay. All right. So
good correction. And so he takes 2 Ambien,
okay.
2 half tablets.
Okay. And for the benefit of the jury, are you familiar with the pill itself? Is it, when you talk about half tablets, is it one that's got like a line, or can it be broken in half? Or
I've taken Ambien before, but not for years.
Okay.
And I worry about the parasomnias, but I don't recall. I just haven't looked at one recently. Again, Dr. Buffington will talk about that if that's relevant.
Do you recall what the prescribed dosage for Mr. Colley was at that time?
Sure, it was 10 milligrams.
Okay. And okay.
And Mr. Colley had told me that he had broken his tablets in half, but I don't recall if they were scored, whether they had that line on them or not.
Okay. I should also ask you too, so maybe this is covered on the record. In your review of Mr. Colley's pharmacy records, medical records, the prescriptions that you provided to was it your understanding these were prescribed by doctors? These
Yes,
medications?
they were.
Okay. So now he takes the Ambien, and then, according to Mr. Colley, what then happens?
Well, according to Mr. Colley, he then slept for a couple hours, and he told me he had been awakened by his father around 8 in the morning. Subsequently, I reviewed a number of texts from him, including some texts which suggest that he was texting around 7. So even though he told me he had gotten 3 hours of sleep, I have reason to believe that either he didn't get 3 hours sleep or he had some kind of parasomnic event around 7, or he was texting, but he has no recollection of that.
Okay. And so his father wakes him up, and then does he then leave the residence and go somewhere?
He does. He has a court appointment. He climbs into his sister's car. He leaves the residence, attempts to leave the residence. He backs into a mailbox, dents the car, but continues driving and goes to his court appointment.
Okay. And was there any part of, from the, I'll try to kind of break this up a little bit in time frames, in his recollection of when he gets up and then goes to court, during that gap of time, any issues from Mr. Colley as far as memory is concerned?
Well, I think there are issues with his memory even before that, because as I just mentioned to the jury, that at 7 he's texting, and yet when I asked him what he had done from 5 until 8, he told me he slept right through until his father awakened him. Okay. So that's the first indication that there's some effect from something on his memory. From then on, through the tragic events that have us here, he has what I would call stroboscopic memory. Like there's a strobe, of course, is an electronic flash. So when an electronic flash goes off, you see a lot because it's real bright, but then it stops going off and you don't see very much. So he has these, another way you might call it is an episodic memory. He has these flashes of memory and then a period of very little recollection for a while, and then another flash of memory, and then another lack of recollection, and then another flash of memory. And that really starts on his drive to the court and continues through the events, and at some point then his memory begins to get a little better as he's driving north.
Okay. Recalling his recollection of the court event itself, did he express any problems with the strobe effect that you're talking about as far as memory? Any issues he expressed for the time frame of the court appearance?
No, I mean, he didn't give me a complete, well, let me go back. One of the issues for me in this case has been that I saw him, as I mentioned, in 2017, and obviously these events occurred significantly earlier. Between the time Mr. Colley was arrested and taken into custody, and I evaluated him, he had lots of opportunity to talk with family, friends, counsel, of course, and so that he learned a lot about what had happened, or what purportedly had happened, that supplemented his own individual memory. And at some point, those two memories, or chunks of memory, kind of merged. And at several points, I had to ask him, now, you're talking to me about what you remember, you're talking to me about what you subsequently learn and remember because you now know that's what everybody believes happened. And that's an important distinction that one has to keep in mind as I am testifying and as I asked him about what had occurred. His recollections often were, as I say, these sort of stroboscopic flashes. But now he can tell you what everybody believes happened because he's read the various reports and talked to you all and talked to family, of course.
Okay. Now, focusing now on the events at the Bellagio house where the shooting occurred, what is Mr. Colley's recollection of that set of events?
Well, his recollection is he drove up in his sister's car to the back of the property, that he had to cross over a berm or a little dirt wall that he saw some people there, including a man, that he got upset by that, that he then has a recollection of going back to the car, but maybe only one or two recollections, opening, I believe, the trunk where there were a couple of guns, has a brief recollection of going towards the house, a recollection of being in the house, and then a very brief flash recollection times two of a killing, maybe two. He wasn't sure in his discussion with me. I mean, obviously, I know there were two, but he wasn't sure what exactly his flash recollections were. He has a recollection or two of them leaving the house and then returning to his sister's house and then beginning to drive north.
Okay. And so when he drives north, as far as the narrative, according to Mr. Colley, what then happens after?
Same issue, that very few splashes of memory. He stopped at some point, obviously for gas, but he doesn't really remember very much until after he's arrested, taken into custody. He recalls being ill for a couple of days, not sleeping very well, having a lot of excessive gastric motility, fancy way of saying diarrhea. And then his memory comes back and is normal. I mean, he recalls then events sort of as we all would, kind of more organic and not in chunks, but in more linearly.
Okay. Without getting too gross, when you're talking about the diarrhea, is there any, in your expert opinion, any connection between that issue and any of the pain medication that he was?
Sure. I mean, the narcotic analgesic, or the opioids, as we say these days more correctly, are potent in terms of causing constipation. And so when you suddenly stop them, the reverse occurs. You get the excessive motility. Very often you get emesis or vomiting as well.
And when Mr. Colley's arrested in Virginia, do you know what he was arrested for?
I don't.
Okay.
I mean, I presume there was some problem with his car, his driving or something, but there was also, I presume, a warrant for his arrest referable to the killings.
Okay. So, all right. Now, having reviewed his medical records, having reviewed Mr. Colley's pharmacy records, your awareness of the medications, specifically Ambien and the other medications, and your consideration of Mr. Colley's recollection and relaying to you of the events that unfolded on the August the 27th, 2015, do you have an opinion as to whether or not Mr. Colley was able to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law? It was substantially impaired.
No, I believe that at the time of the events he was substantially impaired, and I think it's easiest and most likely that impairment was primarily related to the Ambien. But remember, he was taking a number of other medications. Those medications interact with Ambien and cause changes in cognition and awareness. And I believe he was suffering, and did suffer that morning, a parasomnic event that lasted, probably began as early as 7 and lasted sometime through the early afternoon at the least, probably later.
Okay. Having relayed kind of a parallel question, you've talked about the psychoeffectiveness, or what happens when you take cocaine. Let's talk about Ambien. How long would the psychoactive effects of Ambien take place once it's consumed?
Okay. Well, I mean, again, obviously it depends on each person's individual physiology. Ambien is both metabolized by the liver and excreted to the kidneys, so depending upon those functions, it can vary. But in general, if you take a regular Ambien tablet, there's some preparations that have sort of a soft coating and a harder inner part to make it last longer. But if you take a regular tablet, the peak plasma level, that is the highest blood concentration, is roughly 2 hours after taking it, and the half-life of Ambien is roughly 4 or 5 hours, so that within 10 hours there should be some Ambien around, but not very much, wouldn't have much psychological effect. And that's in fact why people have gone to this, the two-part preparation is early Ambien preparations. You fell asleep well, but you woke up 4 hours later and you felt kind of hungover or not, but you really weren't fully rested. So the more modern preparations have a little extra Ambien that sort of in effect brings you down gently.
Okay. And also to talk about going back to the earlier events of that morning of the 27th, you've talked about Mr. Colley relaying how much he had to drink, what he had to drink, for how long, and the cocaine use. In your opinion, by the time of the shooting, of the homicides, what effect, if any, would the earlier intake and consumption of alcohol and cocaine have on Mr. Colley's mental state at that time?
It's my belief that the earlier consumption of cocaine, if indeed it was cocaine, assuming it was, it would have worn off by 3-ish. So there was essentially no effect from the cocaine.
You know, the 3 a.m.? 3
a.m., correct. Well before he tried to go to sleep. He may have had some alcohol with his buddy around 4:30, one beer. So that theoretically, he's an experienced drinker. That could have lasted till maybe 5:30, maybe 6. But I mean, I think by the time he woke up, the only drug that was dramatically impacting his cognition was the Ambien. Now remember, we also have the Cymbalta, and we have these other drugs on board. I presume Dr. Buffington's going to talk about that and their synergy, the lack thereof. But the Ambien would have clearly been effective after 5 a.m. or 5:30 when whatever exactly took it.
Okay. Now, in your course of this case preparation, did you review certain text messages, voicemails from Mr. Colley to Amanda Colley, or vice versa? Did you review those records of those matters?
Yes.
All right. Now, are you aware, or do you recall, for the morning of the 27th at different times, there was text communication and voicemail from Mr. Colley to Amanda?
Yes.
All right. Now, what did you take that into consideration, that information, those documents, in rendering your opinion about his substantial impairment?
Yes, I did. And, you know, I think there's nothing in those documents or voicemails that undercut my opinion as I see it, that you can have, just like you can have a brief stroboscopic memory, you can have a period where you're coherent enough to send a text or leave a voicemail, even if you later don't remember what or why it was you did that.
Okay. All right. Just for a minute, John.
Sure.
I don't believe I have any other questions at this time.
Cross-examination by the state, Mr. Johnson.
Good morning, Dr. Mills.
Good morning again, Mr. Johnson.
I want to first walk you through some of the testimony that you've given to this morning in response to Mr. Wood's questions. And I want to kind of walk us through your interview with the defendant. And as I understand, in terms of making your opinion, in this particular case, interviewing the defendant was very important. Is that correct?
That's correct. And as you heard me testify on direct, and I think it came up in my deposition as well. I spent a couple of days with him, primarily going over his life, his history, the events, all of that.
So let's go back to kind of where you started with your direct examination. The defendant basically told you during your interview with him, going back to August the 26th of 2015, which would have been the night before, he's at his house, he's with his family, and while he is there, has some drinks. Is that correct?
That's correct.
Okay, and what was it again that you said that he told you that he drank while he was there?
I can look at my notes, I don't recall. I think it was a highball of some kind, and I think he had 2 or 3 sometime between 6-ish and leaving the house later.
Okay. And your opinion today is that at the time that the murders occurred, which is around 9:30 the next morning, those would have not had any effect on him, is that correct?
That's correct.
Okay. So he gets a text message from his friend Daryl, correct?
Yes.
And that was around, what did you say, 10 o'clock?
I think he got the message around 10. I think he met Daryl around 11 is my recollection.
Okay. They go to a couple of bars. He has some more drinks, correct?
Yes.
And your opinion today is that those drinks that he had no effect on him at 9:30 the next morning?
No, that's correct. The only thing I would quibble with is when you say my opinion today. I think that would have been my opinion yesterday and at the time of my deposition as well. I'm not changing my opinion just for today.
And I didn't mean that way. I just want to make sure that we were clear today. You also indicated that he told you that he had snorted 2 lines of what he thought was cocaine while he was with Daryl. Is that correct?
No, I think he told me that he sorted a line of cocaine. I think he has told others that he has sorted 1 line or 2, but I think he told me 1.
Okay, fair enough. But your opinion is that cocaine, assuming it was cocaine, did not have any effect on him at 9:30 the next morning?
Yes.
So we get to the defendant telling you about going to his wife's house, correct?
Yes.
So he goes to her house. Did he ever tell you where he parked when he went to her house?
He may. I don't believe it's in my notes, and I probably wouldn't have asked him that.
Okay, so you don't recall him telling you where he parked that night?
Not that night, no, we don't.
He didn't tell you if he parked in the driveway or if he parked around the neighborhood behind like he did the next morning, correct?
It's a fair question, and I don't recall.
Okay. So he goes into the house. He's sniffing around, correct? That's what he told you, right?
Yes.
He finds the whips and the other paraphernalia, and I think the term that you used today was that made him quite upset. Is that right?
Yes.
But actually, the word he used with you was he was pissed, right?
Yes. I mean, I think they're sort of synonymous, but I was trying to be reasonably polite. I may have to change, but yes.
Okay. But he used the word pissed with you.
Yes.
And so when he found those items, he proceeded to destroy three televisions in the house.
Yes.
Now, at this particular point in time, Dr. Mills, other than the alcohol and the cocaine, he's not under the influence of any Ambien, Cymbalta, Wellbutrin. I mean, he's not in a parasomnic event at this particular point. Is that correct?
No. If I heard you correct, I think there are 2 questions there. One is the effect of the medications and/or alcohol and/or cocaine on his mental state, and 2 is a parasomnic event. I don't think he was in a parasomnic event, so I can answer that one straightforwardly. He certainly hadn't taken Ambien that night yet. That was going to be a couple hours from then forward, so he was not under the influence of Ambien. I think both Dr. Buffington and I would say that the effects of the Cymbalta and the other medications he was on, and then the various sort of non-medical pharmaceuticals for weight gain or weight loss, etc., that he was on, could have had some effect, but I don't think it was a substantial effect at that point.
Okay. But the Cymbalta and the Wellbutrin, they're antidepressants, is that correct?
Yes, they're serotonin-specific reuptake inhibitors.
Okay, so they're designed to make you not feel so depressed.
That's their intent, yes.
So he also told you that while he was at the house that he knocked trash cans over, stuff like that, right?
He did.
And he took those, the paraphernalia that he found that made him pissed, he took those as proof of her affair, is that right?
Yes. I mean, again, it's important to say, at this point, she had apparently been denying the affair to him.
Okay, just answer my questions, doctor. So he
didn't mean to stray afield, but yes, sir.
Thank you, sir. But he told you that he took those items as proof, right?
Yes.
Okay. So then he goes over to Mike Dickens' house around 4:30, 5 o'clock. Is that right?
Yeah, I think it's more like 4, but that's close. Yeah.
Did he tell you how he got to Mike Dickens' house?
I don't recall.
Did it tell if he just walked over across the street or if he drove to Mike Dickens' house?
I stand by, I don't recall.
Okay. And so he may have had a beer at Mike Dickens' house, right?
That's correct.
And that beer, in your opinion, would not have had any effect on him at 9:30 the next morning?
I think that's right. I mean, you know, maybe we should be slightly more nuanced. It wouldn't have had any substantial effect, but that's correct.
Okay. So he leaves Mike Dickens' house. He goes home around 5 o'clock. Is that correct? And then he didn't he tell you that before he got home he called Amanda?
I don't recall that.
You don't recall him telling you that Amanda had a conversation with Amanda and Amanda told him that we are done?
That sounds right now, yes.
Okay. And he told her that he would pay for the TVs, is that right?
Yes, he did.
And he told you that he was concerned about the injunction that she had against him, correct?
That's correct.
The injunction that he would have just violated by going into her house and tearing up the TVs and stealing the items, correct?
Yes.
So he gets home, and you said that he took two Ambien, is that right?
2 half Ambien, yes.
2 half Ambien. And you seem pretty certain today that he told you that he took 2 half tabs of Ambien. Is that?
Well, he told me he took 2, and at that point, I didn't know enough to ask him, but he told Dr. Buffin that he...
Okay, I'm not asking you what he told Dr. Buffin, I'm asking what he told you.
Yeah, told me he took 2.
Okay, and since you bring that up, you've had a chance to read Dr. Buffington's deposition, and so you kind of know what the defendants told Dr. Buffington, correct? Are you able to say here today whether or not he took, for sure, either 2 half tabs of Ambien or 2 full tabs of Ambien?
No.
Okay. And then you said that, or maybe you didn't, but he told you that he passed out. Is that shortly after he took the Ambien?
Yes.
Okay. He used those words, passed out.
He did.
And then he slept until 7:30, is that right?
Well, he told me his father awakened him at 8. The text he wrote suggested he was texting some at 7. So I don't know exactly the chronology in there.
Let me ask you about the text, Doctor. When we took your deposition on July the 5th, so just a couple weeks ago, correct?
Correct.
And you never brought up the text in our deposition, did you?
I did not.
Okay. Did you know anything about the text?
I did, but I hadn't read them then.
But you've read them here today.
I didn't read them today, but I've read them over the last few days. Yes.
Sure. You've read them since the deposition.
That's correct.
Did you read all of the text?
I skimmed all of the text. I'm not sure I read every word. I doubt.
Did you look at his phone records?
I did.
Okay, and you were aware that not only was he sending texts, but he was also making and receiving calls throughout this entire time. Is that correct?
Well, which entire time, sir?
Well, that's fair. Between the time that he took the Ambien all the way up until the time he went to court.
Well, he certainly was making phone calls and texting, but he wasn't. I don't recall any calls or texts between, say, 5:15 and 7.
Okay. The phone records will have to speak for themselves, correct?
Fair. Yes.
So in your words, he's told you that he passed out. He slept until 7th. His dad wakes him up. You said at 8 o'clock.
He told me his dad was waking him at 8. That's correct, sir.
Okay. And so how did you understand he was in the bed asleep and his dad comes in and kind of shakes him awake and tells him he needs to get up? How did he tell you his dad woke him up?
I don't recall how his dad woke him up. I recall I said his dad woke him up and told him he needed to get up.
Okay, all right. So at this point, he has to go to court. Is that right?
Yes.
Okay. Now here's a question. He told you that he had court at 9 o'clock, correct?
That's my recollection. Yes.
Now you testified that when it comes to Ambien, the whole purpose of Ambien is to help somebody sleep, right?
Yes.
And you said that you usually take it before you go to sleep, right?
That's the plan, sure.
Right.
It's hard to take it when you're asleep.
That's right. So you take it and you said that the half-life of it was 4 to 5 hours, is that correct?
Yes.
Which means that it should have an effect on your ability to sleep or to help you sleep for at least 8 hours, is that right?
No, well, I mean, I think I said the plasma peak occurs about 2 hours. So the period of greatest effect is going to be about 2 hours after you take it. By the time you get around 4 to 5 hours, and again, Dr. Buffington may know the half-life time better than I, you know, the plasma level is clearly coming down, but there's clearly some ongoing effect at that time. I can't tell you at 8 or 10 hours if there's very much effect. I can tell you that the medication was physically reformed or reformulated because people were waking up at 6 hours out. So I think if you're taking the single tablet dosage that Mr. Colley did, probably the effects are substantially worn off, typically by about 6 hours.
But as you said, when it gets to that kind of half-life stage, it's got that little extra ump to kind of keep you asleep. Is that right? So you don't wake up.
If you're talking about the preparation he took or the new preparation?
Well, you're the one to describe. I assume that you were describing the preparation that he took.
The preparation he took, I mean, you take it, the plasma level comes up, and then the plasma level decays. That at the plasma peak is around 2 hours. At around 4 hours, it's clearly coming down, and it's about half of what it was, and then it keeps falling. So there's less and less effect as we pass the 4-hour mark.
But the purpose of taking Ambien is to help you get 8 hours of sleep, correct?
Well, no, to help you get to sleep. I mean, I think very few physicians require that the patient gets 8 hours.
That's not part of the instructions, is to make sure that you have 8 hours to sleep?
No, I mean, I think the problem is for people who need sleep medication, they don't sleep so well. That's why they're there. And you say, look, I've got some medication that will help you, but I don't know if it'll help you sleep 5 hours or 10 hours if you're asked. My patients rarely ask me that. I'm not prescribing that kind of medication.
So they're prescribing medications just to help you sleep for just a few hours?
No. The intent is to get a good night's sleep, but it's the 8 hours that I'm objecting to, but I don't think anybody precisely measures that time.
Okay. But as you said, that it's in your body having those psychoactive effects for, and I think you said about 10 hours, it's almost gone.
Well, I mean, there's, as I say, if the half-life is 4 to 5, there's some still there at 10 hours, sure.
Okay, so here the defendant told you that he took this Ambien to help him get to sleep at 5 o'clock. That's correct, right?
That's correct, yes.
And he had court 4 hours later at 9 o'clock, correct?
That's my recollection, yes.
And did he talk to you about what his intentions were after he got done with court?
No, he told me about what he did, but I don't think I ever asked him, nor did he ever tell me about what his intentions were.
Okay. Did you ever see the video of him actually coming to court?
I have not seen that. I'm aware of him, but haven't seen it.
Did you hear the audio of when he came to court?
Yes.
So were you aware that when he came to court, he was dressed with a shirt and tie and his employee badge as if he was going to go to work?
Yes.
And so what you understand from the defendant's story to you is that he took 2 Ambien, whether it's 2 half tabs or 2 full tabs. He told you that he took this Ambien to help him get to sleep just a few hours before he had to go to court and go to work.
Yes.
So after he takes the Ambien, his father wakes him up. And then there's sort of this, I think he told you that at that point it was kind of a mad dash. He thought he was late for court, and there was sort of a mad dash. Is that right?
Yes.
And it was in that mad dash, because he thought he was late for court, that he backed into the mailbox. Is that correct?
That's correct.
And it was because of this mad dash that his father had to take his children to school because he wouldn't have had time to do that himself and then get to court. Is that right?
That's my understanding, yes, sir.
Okay. And so he goes to court, is that right?
Yes.
And he handles his business at court.
Yes.
And all of that is on recording, correct?
Yes.
And then he leaves court and And what did he tell you he did after he left court?
I'm not exactly sure. I think initially he headed home, and I think he made some phone calls and some texts, and I think he then went over to his late wife's house, or his house, where she was.
Now, during one of those phone calls that he made after he left court, he told you that he talked to Amanda for about 18 minutes. Is that correct?
No, I don't think he told me the duration of the phone call. I mean, that may be the duration, but he told me to spoke with her for a while, and they discussed, whether she had talked to the police, which she had, and he was upset by that, but he decided to go over.
Would take a look at your deposition, refresh your recollection on that.
I don't have my transcript with me, but I'm sure.
And fresh what is your name? I want to be fair to the adopter, so I'll show you a copy of your transcript. On page 36 and lines 12 and 13, if you'll take a look at that.
Okay, I see it there.
Okay. Does that refresh your memory?
Well, that's obviously what I testified to. It doesn't refresh my memory, however. I don't remember the 18 minutes.
Okay. You testified in your deposition that what he told you was he talked to Amanda for about 18 minutes.
So be it.
Okay. So during that conversation, the defendant told you that Amanda Colley reassured him about the TVs, but said that she had already called the police. Is that right?
Yes.
All right. Said she was trying to fix it, correct?
Yes.
And then he told you in response to her telling him that he felt that she was trying to fix it. Why did she call the police? Is that correct?
That's correct.
And then he said that he needed to give her a check for the TV. Is that correct?
Yes.
So he leaves, so he goes home from there, correct?
Yes.
And that's the house that he lives at with his sister, is that right?
That's correct.
And he goes does he tell you what he does when he gets to the house?
I don't recall.
Okay. Did he have any memory of what he did at the house?
I mean, I think I was moving on to the next event, which was the main event, sadly, but I don't recall.
Okay. So he goes home, and then he goes to Amanda's house, is that right?
Yes.
And from there, you said that he parked, not in the driveway of the house, but he parked at a house sort of behind, in the neighborhood behind their house, right?
That's correct.
And did he tell you why he did that?
No. Let me correct my answer. He may have told me, I don't have a clear recollection, that he was concerned, given the fact that she had called the police, that they might be there. And he didn't want to walk in on them if they were there, because he was obviously violating the restraining order.
Okay.
So I don't recall that, but that may be what he told me.
Okay. So he talked to you about the injunction that he has that kept him from being supposed to be going to her house, right?
I was aware of the injunction. He explained it to me, yes, sir.
All right. So he knew that because of the injunction by itself, he was not supposed to go to her house, right?
That's correct.
And so now he's told you that Amanda told him that she had called the police. Is that correct?
Yes.
And he's told you that he went to her house anyway, but because he thought the police might be there, he decided to park in a place that was concealed, correct?
Yes.
And it's there, after he gets out of the car, that he walks across this berm in the back of the yard, is that right?
Yes.
And that's when he sees a man.
Yes.
Now, he told you that basically he was there to give her a check, right?
Yes.
For the TVs.
TVs, plural, 3.
So now, as I understand, and of course at this point, from what I understand your testimony, he's got this strobe-like memory from this point forward, correct?
Well, no, I think in fact that the memory is like that, or episodic if you prefer, really from 7 o'clock-ish on. That when he doesn't recall to me, he did not recall to me, the phone calls or the text that he had made that morning and that I subsequently learned about when I looked at the texts.
Okay, well, he's standing here in the backyard. He remembers that, correct? And he remembers turning to go back to the car.
Yes.
Is that correct?
Yes,
And he remembers opening the trunk. Is that right?
correct.
Did he say why he opened the trunk?
I didn't ask him. I think at that point I was asking what happened next. You know, keep telling me what you remember.
Okay. He told you, though, this wasn't his vehicle. It was his sister's vehicle, right?
Yes.
Did he tell you what was in the trunk?
At least 2 guns.
Okay. Did he tell you that he knew the guns were in the car?
I don't think I asked that, but obviously he did know that because he went back and opened the trunk.
Okay. It wasn't, he didn't tell you he got the guns from, the front passenger seat, correct?
He did not tell me that.
He got them from the trunk.
That's what he told me, sir.
And then he gets the gun and goes back to the house.
Yes.
And when he sees the man through the window, that makes him upset, doesn't it?
Yes.
Now, going back to these guns he got from the trunk, isn't it true, Dr. Mills, that he told you that it was just dumb bad luck that those guns were in his sister's car?
He did tell me that.
Just dumb bad luck.
That's what he told me.
So he gets the guns from the trunk of the car, dumb bad luck. He goes back to the house. He's already seen the man that's made him upset.
Yes.
And then the next thing, suddenly he's in the front of the house with a gun in his hand. Is that correct?
I don't have him in a location. I have him, he's in the house with a gun in his hand.
Yeah, first of all, John?
Yeah.
37. 13, 14. Showing your deposition from a couple weeks ago, Doctor. If you look at page 37, lines 15 and 16 and 17. 15, 16, 17.
Yeah, and I think that's exactly what I did agree to in the deposition, but I don't have as a here now a clear recollection that he told me he was in front.
Okay. This was a follow-up from a statement you had made that he had a clear memory of being in the house, and I had asked you, was that correct? Make sure I understood you, and you said yes. Is that correct?
Yes.
So he's in the front of the house, and he has a gun in his hand, correct?
Yes.
And then he told you that he jumped over a fence, ran through a door, and then at that moment he blacks out. Is that right?
Yes.
And again, at this point in time, he's got that episodic strobe-like memory going on here.
That's what he told me, yes, sir.
He shoots through the glass door twice, correct? That's what he did. Then he's in the bedroom. He's yelling at his wife. That's what he told you, correct?
That's what he told me.
His wife is yelling. She's reaching for the gun. That's what he told you, right?
That's what he told me.
And then someone's in the closet. He sees a gun in their hand, and you're not sure if he was referring to Amanda or Lindy at this point. Is that correct?
That's correct.
And then he sees blood. That's what he told you?
Yes.
And he told you he had 2 guns. Is that right?
Yes.
The 2 guns he got from the trunk of the car.
That's correct.
He also told you during the course of your interview, did he not, Doctor, that he made the statement, I was always a little hot-headed, always the alpha male. He told you that, didn't he?
Yes, he did.
And then he leaves, he goes back to his house that he lived at with his sister, right?
Yes.
And that's when he got the AR-15.
That's correct.
And then he told you that he said, got to go, got to go. Correct?
Yes.
Meaning that he had to flee the area.
Yes.
And then he's driving on the highway. Is that right?
That's correct.
Now, Dr. Mills, you talked about a lot of things that you reviewed in this case. But isn't it true, Dr. Mills, that the only source of the information that James Colley actually took, the Ambien or any of the other medications, was James Colley himself? Is that correct?
That's correct. You asked me that at the deposition, and I said the same thing.
Okay. That's the only source of that information?
Right. I mean, no one took a blood level from Mr. Colley. We don't have anybody else who saw him take the medication. So far as I know, that's correct.
Okay. The only source of information that he took the medication as prescribed was James Colley. Is that correct?
That's correct.
And the only source of the information that it had any effect on him whatsoever is from James Colley, correct?
I think that's substantially correct.
And so, Dr. Mills, your opinion here today that the defendant was suffering a parasomnic event at the time that he killed his wife and Lindy Dobbins rests substantially on what the defendant told you concerning taking the medication, how much he took, and the effect that it had on him, correct?
On that, and upon the fact that it was prescribed, and that he told me he was taking it as prescribed, and on the fact that a variety of other medications were prescribed, which could and I believe did interact with the Ambien. Yes.
Okay. Let me ask the question again, because I think the answer might have been lost in what you just said. You had records that said he was prescribed these medications, correct?
That's correct.
But whether or not he took them as prescribed and had any effect, the source of that was based solely on his testimony.
His statements to me, yeah, was the testimony.
His statement, correct.
That's correct.
So your opinion about the fact that he took the medications, took them as prescribed, and had effect, rests almost completely on what he told you, correct?
That's correct.
And if he told you a lie, and he didn't tell you the truth, that would adversely affect your opinion here today, correct?
That's true.
Nothing further, Your Honor.
Any redirect, Mr. Wood?
Yes, briefly. Going over a couple of points that Mr. Johnson made, you were told that he backed into a mailbox.
Absolutely.
And that he dented the car as a result of that.
I was, and I believe it.
Is that consistent, in your opinion, with impairment?
Yes.
Now, when Mr. Colley was at the house where the shootings occurred, did he describe anything that we would call a panic attack?
He did. Early on, he told me about feeling just dread and anxiety when he first approached the house.
Okay. What are we talking about from a medical perspective when we're talking about panic attacks?
Well, it's not exactly clear, but I mean, in general, we're talking about a fight-flight reaction, a big surge of adrenaline, or epinephrine, if you prefer, and feeling very jittery, and he describes feeling very jittery and frightened.
Okay. Now, in your profession, in your experience, practicing medicine and psychiatry, you prescribed Ambien for patients before, is that correct?
Many times, sure.
And do you ever advise your patients to take Ambien knowing that you're going to have to get up in 2 or 3 hours?
Never.
Okay. And from a medical perspective, why is that not a good idea?
Well, as you heard me say, the peak plasma level is around 2 hours, so if you knew you're going to get up in 2 hours, that's when its effect is the greatest. And as both from my clinical work and from my forensic work, I've come to appreciate that taking Ambien has real risks of parasomnic events, of lack of memory, when we talk about falling down escalator event, that there are risks associated with it that make me think it's a drug I would not want to prescribe in general.
Okay. All right. Thank you, doctor. Appreciate it.
Any recross, Mr. Johnson? No, Your Honor. Dr. Mills excused, Mr. Wood.
I'm going to have him stick around, Judge, for future rounds.
All right. You are relieved from the witness stand, but not excused.
Okay, thank you, Your Honor. I appreciate the distinction.
All right, folks, we're going to take our lunch break at this point. It's exactly noon. Let me remind you during the lunch break, please do not discuss the case amongst yourselves or with anybody else. Don't do any research of any type, and leave your notes here in the courtroom. They will be secured during the break. It is, as I mentioned, precisely noon. Let's have everybody back at 1:20. 1:20 back in the jury lounge. And as soon as we have everybody gathered up, we'll get you all in and continue on. Thank you, folks. Enjoy your lunch. Anybody else remain in the court? What do you have for the afternoon? What do you have lined up?
Judge, our next witness is going to go out to be Dr. Quiroga. It's Quiroga. First name is Michelle. I don't know the exact order, but I have lay witnesses: Gail Dickens, Marie Robert Isaac, John Wright, John Schwinghammer, Frederick Cartwright, Jason Deloach, April Ayala, and maybe Mr. North and Chris Wright, depending on how we're doing on time frames. Just so you know, my preference would be for certain strategic reasons. I'd like to see we get up to the point where I would next call Ms. Wright. I'd like to call her after Dr. Bovenu, who cannot be here today. It's going to be at 9 o'clock in the morning. So I might be asking the court for just a slight, if we finish a little bit early on that issue. FYI, we had some rescheduling of Dr. Meadows' deposition, which is going to be done at 5 o'clock today. So anything along those lines would be helpful too.
Okay, thanks for sharing that, because I didn't realize y'all had a deposition at 5 o'clock. Okay, sounds like we'll have enough witnesses to occupy most of the afternoon.
If we get that far, then I'll only have 2 people left for tomorrow. They'll be done in the morning, and then it'll be whatever the state wants to go.
Okay, very well. Then we'll be in recess until 1:20. So everybody enjoy your lunch.